I always say law ultimately is about relationships. It's about managing relationships between people or entities.
Welcome to the Business Behind Your Business, conversations to help your business grow and thrive. Hi, I'm Paul Sweeney, founder of Pretium Solutions, Chartered Accountants and Certified Business Advisors, hosting the Business Behind Your Business. Today I'm here with Philip Vanden Heever from Frank Law, obviously a law firm, but a law firm with a difference. So good to have you here, Philip, and you want to tell us a bit more about who you are and what you do?
Yeah, good morning, Paul. Thank you. First of all, thank you for the opportunity. I really appreciate it. Obviously, not only to do the podcast with you, but to be on the advisory board. I really appreciate the opportunity and I'm excited about it. So looking forward to that. Yeah, so Frank Law is a boutique law firm based in Parramatta. We serve the wider community of Western Sydney and obviously Northwest. So we have the privilege to serve people in the community with our legal advice, and that's the way that we want to conduct ourselves as well. You know, is with professionalism, I suppose, and humility. So that is what we do. In terms of this different areas of law that we practice in, we have a corporate team which looks after businesses, their corporate needs, their commercial needs, the agreements, and all those type of issues that they might face in growing the business, starting the business, or even when they want to exit the business. We also have a family law team who are looking after when there's a family breakup. A specific speciality, I suppose, is family breakups where there's a business involved, is something that we are quite good at, if I can say that. And then we also have a team of wills and estate planning, looking after people's estate and succession planning, what happens to the end of their lifetime. So that in short is Frank Law. We're about 16 or 17 employees based in the heart of Parramatta. Yeah, and it's my absolute pleasure to be here. Thank you. Appreciate it.
So quite a comprehensive skill set within Frank Law. And there are a number of things you just mentioned about where a business owner would actually be able to utilise those skills. And often what we see from an accountant's point of view is that our clients don't tend to engage a lawyer until something's gone wrong. And often that's too late from my view. If we could engage the lawyer and get the advice up front, then we're going to get a better outcome. So when's the best time to start working with a business lawyer?
Yeah, that is absolutely true, Paul. I mean, so many times I would get clients coming to us and I would just say to them, if you just came, a few months earlier, we could have put things in place to manage this risk. My advice is to all business owners is to, as early as possible, obviously when you start a business, start off the right track, especially if you're entering into a business with a business partner. When the relationship is still in the honeymoon phase, where parties are willing to compromise with each other. It's those times that you need to get structures in place, like a shareholders agreement or a partnership agreement or joint venture agreement, whatever type of relationship you're entering into, to make sure that these things are properly recorded so that both sides know exactly, all right, this is the basis upon which we are entering into this deal together. This is the basis upon which it will be dissolved. This is the basis upon which we will resolve disputes. But also then from what I would call below the line type of documents, making sure that you have your proper terms and conditions, your proper employment agreements, your policies and procedures. If you have a website, a proper disclaimer documents, privacy policy, all those legal documents which are needed to protect your business from risk. Another important factor is for when people start their businesses is how to protect their personal assets. So from our point of view, there are ways by the use of trust or some other mechanism where a person, when they start a business, protect the risks that their personal assets might have in entering into or starting that business. Now, I want to make it clear, we as lawyers obviously look at risk and try to manage the risk associated to that. Now, there are always other elements that goes with that, like tax, like business, and that's when we go to people like yourself to work together with the accountant to come up with a structure, with a plan, with a process to make sure that risks are sufficiently dealt with, but also from a tax effective point of view is implemented. So yeah, to get to make a short to answer your question shortly, it is from the beginning, as early as possible, not when a problem arises, because dealing it with at that stage just causes so much more difficulties. And, lawyers are expensive. That is a fact. And you can save yourself a lot of money if you don't go into too much trouble later, if you have, from the start, your processes and documents in place.
Yeah, prevention is certainly better than the cure. And getting, I think we all know that new feeling when you buy something new, it's in the best condition it can be. And even when it does get some damage, it's not as functional or as aesthetically correct. So it's good to get those things in place right at the beginning. Now, we're talking about shareholders agreements because I think that's a key thing, and I've seen plenty of instances where there hasn't been an agreement in place and things have gone bad. When things have gone well, and look, I'm thinking back to a situation where we had 3 or 4 people in the business, and there was a very watertight and well constructed shareholders agreement. One of those shareholders was killed in a boating accident, and the spouse was obviously distressed but didn't want to go through the situation of dealing with all the ins and outs. But we had a very clear process set out in the shareholders agreement, a very smooth process. What ended up happening was the spouse was able to grieve without having to worry about the business side, and the mechanism was in place. We had a very clear statement of what value was and the terms of which they would be paid. So that's a great example of when it works well.
Absolutely. They call that a buy-sell agreement, which is basically when one of the shareholders is either become incapacitated or when they die. Of course, we have many. The questions I ask our clients is, how well do you get along with your business partner's partner, wife or husband? Because guess what? If somebody happens to your business partner, they are probably going to become the one that you have to deal with and that you have to have a relationship with. But luckily there are processes. There's an agreement called a buy-sell agreement where you can agree beforehand that if something happens to me, that the other business partner can immediately buy those shares off the estate. And as you rightly said, there are certain processes agreed to about what the valuation is, how it will be valued, and how that will occur, which can take a lot of anxiety out of the process. Another issue is if the person dies without a will, you all of a sudden have a public servant to deal with a public trustee to deal with in terms of those shares in your business. Yes. The matter becomes just a number, and you're in line until they get time to deal with it, and all of those things place stresses on the business. And luckily there's I'm not an expert on it, but there's obviously, as well as key man insurance, that a business should take out, so that if you and I are in a business, if I pass away, at least the company has paid them for insurance, which allows you to purchase those shares of my estate. There are a lot of things that you can do to make things easy and to avoid disputation, because at the end of the day, that is the thing that causes stress. That is the thing that causes money, is disputation amongst shareholders and business partners. So again, rather sooner rather than later. Yeah.
So just to clarify, the buy-sell agreement is a separate agreement to your shareholders agreement?
It is a separate agreement. I have seen a shareholders agreement which includes a buy-sell, which is not a problem, but we recommend it to be 2 separate agreements. That should be drafted and tailored to the business.
Okay, so that's good. And what sort of things go into a shareholders agreement other than obviously the buy and sell? What are the common things that a shareholders agreement deals with?
There are obviously varied terms that could go into it depending on the business. But if I can turn to the basic stuff, it is about. It usually would say who can appoint directors, how directors are appointed, how they are or could be removed, how shares are transferred either to third parties or amongst the shareholders, which usually you will have provisions that allows the other shareholder to have a first right or an option to purchase before the other shareholder can sell off the shares to his mate. which you might not go along with. So those type of things. There's what we call drag along or tag along provision, which basically deals with should there be a buy, should one of the shareholders receive a buyout from someone else. The other shareholders can say, wait a minute, I want to participate in that sellout. You must drag me or tag me along to whatever that deal is. That sounds good. There are, as you say, there are termination provisions. How does this company dissolve? Who gets the IP? What happens to the assets of the company when this business comes to an end? How do we value shares? It's those type of provisions. How many board meetings do we have per year? And just what can directors do and what can't they do? What requires unanimous vote? What can a director majority vote? It's all those type of decision making, I suppose, in helping and understanding before you start the business, how are we going to manage this business going forward, and what can I do and what can't I do. One must always remember that there's a layer on top of every shareholders agreement, which is just your duties as a director, which, you know, it's always advisable to get advice from a lawyer about what are my duties as a director. You know, there's duties of good faith, there's duties of trust and fidelity, there's duties of all those type of provisions, so that you understand what your duties as a director there are. So that's the shareholders agreement. That's basically, you know, a very important document that should be entered into shareholders.
And one of the things I think that often gets overlooked, I've seen, is the dealing with how funds are contributed by the original shareholders, and should they be separate loan agreements, and how do we provide for when do those loans get repaid by the business, on what conditions?
Yeah, look, when it comes to directors' loans, as we call it, it's always important to have those director loan documentation very carefully drafted and put in writing. And the reason for this is that should the business go into liquidation, it is very important that a director can say, wait a minute, I've got first rights to claim money. With that, we would recommend, registration on PPSR maybe over some assets of the company, to make sure that the director's interest loan to the company is protected. Of course, that loan agreement will obviously set out how things are paid, how things are, how the loan is repaid over time, etc., etc. It could be by the issuing of more shares or whatever the case might be. It really needs to be tailored to the business. More importantly, also, is that what will happen if this company, if we agree, decide to separate paths? What will happen to the directors' loans? How will that be funded? How will that be paid? Who gets what? And all those type of things. Yeah, so you're absolutely right. Those internal relationship documents recording exactly who gave what, who contributed what, should be well documented, and to ensure that people's rights are protected. Should they should something happen to the business?
Yeah. Well, I think we all know that at some point every business ends, whether by choice or not.
Yeah, correct.
So you need to have a mechanism in place. So we talked about today. So we've talked about 3 key documents as part of setting up a business. So your shareholders agreement, your buy-sell, dealing with how people will exit, and loans.
Dealing with the directors' loans,
Yeah, so 3 key things, and of course the advice is always start working with a lawyer, a business lawyer, right at the beginning.
I think especially the shareholders, all these agreements, but in particular the shareholders agreement, because negotiating a shareholders agreement, especially where there's a minority shareholder involved, is always hard and difficult, and it forces the partners to have discussion with one another about uncomfortable things, about what will happen, what can I as a majority shareholder do if push you out or anything like that. So it's important that those things are discussed when the relationship is still fresh and new, and as I said, in the honeymoon period where both sides are willing to compromise, because I would suggest that if you can't agree on a shareholders agreement at the beginning of your relationship, you're going to find it extremely hard
Yeah.
in managing your business.
Yeah.
And it's rather that you know that before you, or at the beginning of your business, than finding that out much later.
And that raises a really good point there, because I think there's this excitement about starting a business, and often what I see is that the structure is set up, the commitment is made, the first customer is
The website is built.
The website is built, everything. Well, the website's always a priority, because they get that out there. But then the shareholders agreement becomes an after event, and then at that point you're sort of already entangled with each other, and it's harder to come up with those hard terms.
That's right. And what we usually find, Paul, is that what business partners would enter into is what they call a MOU. And an MOU, generally speaking, is not enforceable.
Okay. So an MOU is a...
So MOU is a memorandum of understanding. Now, that could be what would usually happen, and I'm just using examples. I'm not saying that's always the case. There would be an email between the guys. Hey, let's start a business. You get that, I get that. And then one would say, you know what? From that arrangement that we've now made through emails or whatever at the pub at the back of the beer coaster, let's get a document together, and we can say we agree to these things. And they think that once they've done that themselves, and they sign it, that's it.
Yeah.
Whereas an MOU is usually an intent to enter into agreement. There are 6 elements, I'm not going to go through them now, but there's 6 elements that constitute what makes a contract. A MOU is usually an intent to contract. It's not enforceable in law. But people often think that once I've got the MOU, I've got this little document that we agreed on without getting any advice on. And then usually there would be a term like, the parties agreed to enter in a shareholders agreement, blah, blah, blah. And then that shareholders agreement never happens. Because they think, we've done that. We've done the negotiations. It's all fine. We don't have to worry about a shareholders agreement. They might find that they're a bit, fallen short of what they think they entered into, and whether it is legally enforceable, whether it can be relied on. Now, I'm not saying an MOU is worthless. Yes, it shows intent. But enforcing it, thinking if there's something in the MOU that you agreed to and you think that 2 years, 3 years later, when it goes pear-shaped, you want to rely on that as an entitlement that you should get when the business dissolves, that's hard. That's an extremely difficult thing to get yourself out of. It might cost you money to do so. So that is the danger people often do, is that they think they enter into these handshake deals or MOUs and think that that's the end of the story. We are good to go.
Yeah. So it's a classic example of you don't know what you don't know.
No.
And really, unless you're actually already a business lawyer yourself and have those, well, if you're a business lawyer, you'd be putting those agreements in place, but most business owners don't have that background. So this is where it's crucial to engage somebody that does have that experience and that skill set.
Yeah, absolutely. Look, for us as lawyers, it's always helpful if there is a MOU to draft a shareholders agreement, because you can just say, look, Philip, here's the MOU. Can you quickly draft us a shareholders agreement based on that? But I think as people go through that process of us drafting the shareholders agreement based on the MOU, they raise a lot of questions are raised, and which we push back to client and say, your MOU says X, but how does that actually translate in a legally enforceable document? And people might find that there's a lot of unanswered things that MOUs don't address. So it's important to get advice from the start, as you say, on these things, making sure that you've got your ducks in a row, so to speak.
Great. Well, that's all great advice. Well, not just for people for starting business, but anybody that's in business. If you don't have those agreements in place, you should do so now. Well,
that's right. I almost said it's never too late, but actually it could, in some instances, be too late. Trying to get something across the line when there's a disagreement and when the relationship is already strained is actually almost impossible. So it's better to do it when you're on honeymoon.
Great. So what's one big thing, the one key thing that you would like to leave people with when we're talking about agreements? What's the one key thing they need to remember?
I think one of the key things to remember is that agreements ultimately is between two people or three people or more. The point is it involves people. People change. People develops. Relationship changes. So it is important that when you commence a relationship, that the terms upon which and the expectations of that relationship is agreed to in writing. Even it is as difficult, even when there is a signed agreement, it's sometimes clear from the parties' conduct that they didn't even intend that. So it just makes it so much more difficult. People, I always use the analogy. If you and I are standing on the different side of a tree, and I describe to you the tree that I'm seeing from my perspective, and you are standing on the other side of the tree or on another angle, you obviously see a different shape of the tree, correct? There's certain branches you don't see that I see, and there's certain branches that I see that you don't see. We might be describing the same thing, but the people, you and I have different perspectives. And that's the exact same when we enter into a business, into a relationship, is that what you perceive to be the deal between us is 99% of the time different to what I perceive the deal might be. A document helps you to actually see the tree from both sides and have it all together and give certainty for parties about what the nature of relationship is. And here I'm talking not just about shareholder relationship, I'm talking about employee relationships, I'm talking about supplier relationships, if you have a distributor relationship, I'm talking about your customers, just your normal terms and conditions. What are the expectations of this relationship? I always say law ultimately is about relationships. It's about managing relationships between people or entities or companies. That is what the law tries to regulate. If you take traffic law, for example, you might say, well, where's the relationship there? Well, traffic law is between you as a road user and somebody else as a road user. It regulates that relationship. And that's the same with agreements. It regulates relationships. So agreements in all facets or aspects of your business is so critical to have in place. Whether it is, as I said, to your employees, or whether it's just managing your debtors or your creditors, whether it's managing your suppliers, who supplies what happens if it's a faulty product, who gets the fault, who fixes it, all those type of things that we think we understand what's going to happen if you give me a thing that's faulty. Turns out not to be the case. So that's why agreements and policies in your business is so important as it relates to people, it relates to management of that relationship to protect your business.
Great.
I know that's a long point, but I think it's so critical to say.
Absolutely. Well, Philip, thank you very much for your time today. It's been some great knowledge shared there, and we just hope that more business owners are proactive and get these agreements in place to protect those relationships that are so important.
Paul, thank you again.
Thank you, Philip. That was Philip Heever from Frank Law. We're going to be talking again with Philip in the future episodes about employment law and other aspects of law that all businesses should be aware of. Thanks for listening. Do you have a question you'd like our team of experts to answer? If you do, send your question to podcast@thebusinessbehindyourbusiness.com. To hear more from The Business Behind Your Business, don't forget to subscribe using your favourite podcast player. Or you can visit the businessbehindyourbusiness.com website.